Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about emojis. Cases that should have gone to the Supreme Court of Canada, but didn't. In a contract for the sale and purchase of some flax, the buyer sent a set of terms and conditions and delivery issues to a seller, and the seller responded with a thumbs up emoji. As a result of that, a contract was formed, or at least that's what the buyer thought. The seller thought the thumbs up emoji was not creating a contract. And when the buyer sued the seller, arguing that they had violated the contract that had been created by not delivering the flax that had been ordered, the seller argued in court that a thumbs up is not an acquiescence to the contract. The court, however, disagreed, and the Court of Appeal also upheld the finding that an emoji of a thumbs up is meant to communicate approval or acquiescence, and that an emoji itself can form the basis of a contract. This is perhaps one of the first cases in Canadian law to interpret the use of an emoji to create a legally binding contract, especially one with significant financial implications. And the Supreme Court of Canada denied leave to hear this case, but this is an important case that raises very important issues. More and more we are seeing in legal cases not just people's verbal statements and not just people's written statements, but also now their pictorial statements, whether it's people sending a GIF or a GIF in response to something that's been said to them, whether it's somebody sending an emoji. All of those things can have different interpretations. The eggplant emoji, for example, to some people means certain things, whereas an eggplant just means an eggplant to other people. And the court needs to understand the use of emojis and have evidence in relation to how emojis can be used, but it also needs to understand that the communication methods that we use today are very different than the communication methods that the law of contract developed around, or all sorts of other laws where emojis have also been implicated. And it would be important for the Supreme Court of Canada to really define how our modern ways of communicating impact whether or not a valid contract has been created. There may be circumstances in which there isn't a meeting of minds about what a certain emoji means, where emojis are used differently in different cultures or different places in the world. And so having some clear guidance from the Supreme Court of Canada on the interpretive exercise of what an emoji may mean and when an emoji may give rise to legal obligations or legal consequences would be helpful and important. Unfortunately, it's going to take another emoji-related case to have the Supreme Court of Canada potentially consider this issue. And in the meantime, probably don't use emojis to communicate about important legal matters. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.